Good morning, everybody. My name is Nick Barnes. I'm the outgoing chapter president. Welcome to the 2021 CAI Central Ohio chapter virtual annual meeting. I have to say it is a little bit awkward since I can't see your faces, and hopefully we can return to a sense of normalcy here soon. I'm going to go ahead and call this meeting to order at 11:33 a.m. First, I want to start by thanking everybody for their commitment to the chapter and their flexibility during the very, very difficult year and unusual year that we've had. At last year's annual meeting, I said that my primary objective was to increase the engagement of all chapter members in our chapter. And we started off strong. A lot of the members joined committees shortly after the annual meeting. Committee membership growth is one of the best ways to increase chapter engagement, at least in my opinion. Many of you on your committees had already started planning the luncheon programs. I think they were actually planned out through the year. Started on trade fair planning, the manager's only event, the chapter social outing, the golf outing, different volunteer activities. Things were starting to go very well and get planned. And many of our business partners committed to sponsorships for the chapter and in some cases specific events. And so we were ready for a very full and engaging year. And then of course the pandemic hit and everything came to a screeching halt. And our chapter kind of fell, we started to follow the lead of CAI National, which was also scrambling, and they quickly tried to adapt to a Zoom format, and they had meetings at least monthly with chapter leadership, all of its chapters, to see if there were virtual opportunities and things like that. And so we tried some of the virtual opportunities, and a lot of the feedback that we got from our chapter members and committee members is that virtual is hard for our chapter. There's a much stronger preference for in-person engaging. And that was actually very evident at the one in-person event we were able to have, the golf outing. And I kind of sat back and watched all of you interact with each other. And it was very clear that that's our preference. That's kind of our bread and butter. And hopefully we can, adapt a little bit if this pandemic doesn't ease up soon and things don't get back to normal. But my hope, and I think the hope of the rest of the chapter and the board, is that the pandemic will get under control soon and we can start, return to a sense of normalcy and safely get back together. But I personally want to thank our chapter executive director, Debbie Lee. She did a fantastic job transitioning into the new role of CED this year. She did it seamlessly, and I think she'll be an asset moving forward. I also want to thank the board, despite the fact that we weren't able to, that we were trying to, adjust. We still held our monthly meetings, and we still kept the board, the association and the chapter afloat. And I think we have a solid foundation to, so that our new president moving forward will be ready to start right off the bat. And I also want to thank our sponsors first and foremost. Without them, we wouldn't be able to really sustain this chapter the way that we're able to. But by way of business items here, first thing is that for our panel, they're going in blind right now. There's no questions. Go ahead and submit your questions for the Q&A section. There's a Q&A box in the Zoom, and it's going to vary depending on what kind of device you're using for this meeting. But try and find your Q&A box and start typing some questions that you have for our panel. We do have an excellent panel, and I look forward to that section. Moving on to a business item, the 2020 annual meeting minutes were approved by the board at its first meeting after the annual meeting. The approved minutes are available in the members only section of our chapter website. So if you go to our chapter website and caicolumbus.org and you go into the members only box, the 2020 annual meeting minutes will be there along with all of our other chapter documents. Another business item is we are soliciting nominations for a legislative action committee member from our chapter. So the Legislative Action Committee for Ohio has representatives from each of the three chapters in Ohio, the Ohio Valley chapter near Cincinnati, the Cleveland chapter, and here. We had two representatives, one after committing to serve, had to resign. And so we need to fill that role. Now, the Legislative Action Committee is like our chapter board, which that there can only be a certain percentage of its members that are from specific categories like business partners, manager members, and then volunteer leaders. Due to the current composition of the LAC, we can only nominate a volunteer leader or a homeowner. So if you are a volunteer leader and you would like to apply, please reach out to the board. And first reach out to Debbie Lee. She's probably the best one to contact for that. If you know of a volunteer leader that you think would be good for the position, let the board know, or Debbie Lee. They will need to be members to be on there. So if they're not current members, they can sign up and then serve on the LAC. But we just need one volunteer leader to serve in that LAC position. And if you have questions about the role, you can reach out to me or Debbie Lee, and we can fill you in with all the information that you need. Okay, so the next item is our chapter president for this coming year, 2021, is going to be Brandy Smith at Associa. Brandy's going to be fantastic. Unfortunately, Brandy isn't able to make the meeting today. She really wanted to be here. She just could not attend. And so she will be an excellent leader for the chapter moving forward. I'm excited to see how the chapter goes forward with her as the leader for this year. Next, we have our chapter treasurer, Julie Jerem from Devon and Associates. Julie's going to give us an update on the financials of the chapter.
Good morning, everyone. A warm virtual welcome to all. Thank you for joining us via Zoom today. I'm Julie Jerem, the treasurer of the CAI Central Ohio chapter, and I will be presenting just a brief financial summary for our fiscal year end. We concluded the year with approximately $31,000. We've got 2 accounts held in a checking and savings, both of which are at PNC Bank. This year, for the 2020 year end, we generated about $54,000 in revenue, and our expenses totaled approximately $42,000. Overall, we ended the year with a net revenue or surplus of approximately $12,000. As you may or may not recall, we ended the prior year with a deficit, and our goal was to prevent that from occurring again in 2020. Mission accomplished, albeit the majority of the surplus in 2020 relates to the decreased number of events that were held throughout the year. Therefore, we did retain those funds. We have more to spend this year in the coming year, so we can make up lost time and spend more time together face-to-face, hopefully very soon. I would like to take a moment to thank each one of you for your continued support of the Central Ohio chapter in 2020. I think we can all agree it was a very challenging year. Nearly every business throughout the world was impacted in one way or another from the COVID pandemic. We are looking forward to a brighter year ahead and cannot wait to see all of you again soon. I did want to wish good luck to all the candidates today. We sincerely appreciate your willingness to volunteer. You have valuable time and resources, and I do understand that they are minimal at times, and we appreciate your willingness to volunteer for our organization. We look forward to your new input and ideas, and hopefully you will help us to continue running the chapter successfully. Thank you.
Thank you, Julie. And now we're moving on to the results portion of our board member election. And I'm going to punt to Arnold on this. Arnold is the chair of our nominating committee due to his role as the 2019 chapter president. And so he's leading the efforts, but I do want to echo Julie's appreciation for all those that ran. And, you know, I look forward to all of you that did run, continuing to remain engaged in the chapter moving forward. So go ahead, Arnold. Thank you.
Thanks, Nick. Thanks, Julie. As the immediate past president, it's my honor and privilege to chair the nominating committee. I would like to thank Kathy for her support in making this whole meeting and this election take place. It was her experience in virtual elections that really helped guide us. I thank the board as well for having a couple of long meetings to discuss how this process should work. And then obviously the nominating committee that helped me find some candidates for this election as well. The board of directors for CAI is made up of 7 directors. They're coming from several membership categories, the community association volunteer category, community association manager category, and the business partner category. Along with that, we have an at-large membership, but no director category can be filled by more than 3 members. Nick Barnes and myself are the ones exiting the board of directors because of our term limits, and that left open positions available for any of the categories: association volunteer, association manager, and the business partner membership. The election process and the nomination process, I thought, went very well. We sent out notice to the entire membership. We solicited and received several people that were interested in being on the board, so we did have a contested election. We then gave everybody in the membership the ability to vote. I think it was about a 2-week period to collect all of the votes so we can have the election results announced today. And most importantly, I want to thank the candidates for that volunteered for this position. It is very honorable for each person to want to volunteer their time for this election and for the membership. So the term for the elected board members, there are two elected board members. They're going to be for 3 years. And the first winner I want to announce and congratulate is Jim Ambrosio. So congratulations, Jim, and John Bowers. Congratulations, John. Both are fine members of CAI that have taken roles in the chapter for many years, and so I'm happy to have them on the board. Thank you.
Thank you very much, Arnold, and thank you for your service on the board. I appreciate everything you've done personally, and I know that the chapter appreciates it, especially serving as president. So thank you very much for your time and efforts over the past few years. Now, before we get into the Q&A here, I do want to let everybody know we only have 3 questions so far. You have this whole panel and knowledge, right before you. So if you have questions, make sure you get those in by entering them into the Q&A box wherever it is on your computer. But again, I do want to thank all of our sponsors for this year. As everybody said, without them, without your sponsorship and your assistance throughout the year, we wouldn't be the chapter that we are, and we do thank you. We look forward to engaging you in the future and really partnering with you moving forward. So now, with that said, I'm going to go into today's program, and I'm going to have to make up a lot of questions if we don't get some questions here. But we have 3 community association specific chapter member attorneys that are very knowledgeable that are going to answer your HOA and condo questions. Julia Donnan from Brocius Johnson and Griggs, Jeff Kamen from Kamen and Cusimano, and Jesse Konitz from Williams and Strom will be answering all of your questions. And I will be moderating to the extent that I can here so that hopefully I don't jump in too much. But so with that said, we'll go into our panel. Oh, we're up to 4 questions. So let's see here. We need to get our panelists visible. We got Jeff, we got Julia, just need Jesse. Oh, there he is. Hey, everybody. Thank you again for agreeing to serve as panelists. And I'm going to make up some doozy questions here if we don't get some more. But I'm going to go ahead and start with the first question. And the format I'm going to do is I'm going to ask the question, and I'll let whoever wants to answer it. Now, if I see somebody's taking too much time, or answering all the questions, I'll pick on the one that's not answering just so we can make sure everybody gets a chance to speak. But the first question is, since many associations were not able to host their annual meetings in 2020, if a pandemic continues into the summer of 2021, what alternatives do associations have to host an annual meeting? A Zoom option? ? Hold outdoors, practicing social distancing and mask wearing? What are your thoughts? Who wants to take the lead?
I can jump in on this one, and I imagine that everyone, Jeff and Julie, you might have something to say on this. I mean, if 2020 and 2021 had a question of the year, I think that's it. It's one that I know I've answered for multiple associations, and I can say it's one I've answered differently, both as the pandemic has kind of progressed and for particular associations. So I'm not sure if there's a one answer that I would give for every association. When this all started, I was initially telling people, well, let's just wait and see what happens. Maybe it's all going to be over, come June, and then we can just do our meetings then. Obviously when that didn't happen, it became, okay, how are we going to start having these meetings under these conditions since they're not going away? And again, I think you have to take an association by association look at it. So, first, how big is your association? How many people are coming to your meetings? If you have a younger demographic in a smaller community, I think Zoom might be something you could look at and maybe would work. For some of the larger communities or maybe an older demographic that might not be as tech savvy, I haven't seen Zoom as a great option for that. But that being said, I've gone to outdoor meetings this year or 2020. I've done absentee ballot or proxy meetings. I've had, I think, one actually go forward just because it was a smaller community and go forward with the in-person. I'm tending now to recommend more of trying to do it via a proxy process, not having people come in, especially for a larger community. I just don't think it makes sense to try to force people to come in under these conditions. So that's how I've been going about it. Most documents allow for proxies and allow people to attend the meetings via proxy. So that's how I've been doing it. It does require some more mailing and more manager time to do it that way. You're usually going to have to solicit nominations via mail, get those, and then send out, once those nominations are in, send out another proxy form and get those back and do your votes. But I've been having good luck with that. The communities I've represented that have done it seem to like it. And it seems like the communities are understanding why you're not having a traditional in-person meeting. But as I said, I'm sure Julia and Jeff, you guys have had different experiences or similar ones.
I'll jump in. Yeah, I think you kind of hit the nail on the head. Each community is different. It depends on, as Jesse said, what stage of the pandemic we're in. It changes month to month, week to week sometimes, but also the size and demographics of the community. We've seen some communities discuss even a hybrid approach in terms of some sort of electronic communication, but also handle more of a proxy mail-in ballot sort of situation. Honestly, if there's anything, I think that just with CAI and CAI's operations, it's really impressive how adaptable and flexible people have become as a result of this.
I think to echo all of those things, to me, Jesse hit one of the nails on the head, and that is with this question and any other question we answer today, oftentimes the answer is very specific to your community. And so really before making big global decisions, you should always talk to your council and look at your community's governing documents. Some associations have very specific election procedures that have to be followed that we just can't avoid without an amendment or something else. And so, certainly in general, there are lots of options to consider, but we absolutely need to make sure that in each individual community circumstance that we're doing the right thing. And this has certainly been something that's at the forefront of everybody's mind, and we want to do it correctly, but we also want to make sure that we're having annual meetings. It's interesting. I know at least we've seen actual lawsuits now being filed over this topic. We have one instance where an association didn't have an annual meeting in 2020, and one of the owners thought that was an abuse of power and has filed a lawsuit. We have another one that is being filed over the annual meeting procedure, saying that it wasn't consistent with what's in the governing documents. And so that's why it is very important that we're following each community's requirements as necessary.
Yeah, and that brings, you raise a good point here in that all of these answers are going to be community specific. So I do want to be very clear in that although this is a legal panel, nothing should be construed as legal advice for any of your specific associations because they are, the advice has to be specific to your association because they all have different documents and different considerations that need to be taken into account before a formal legal opinion can be given. So I do want to, so it's going to be a lot of it depends, a lot of general answers, but that's just the way this goes here.
We're lawyers. That's how this works.
Yeah, it's very,
disclaimers. It's gray.
But going on with this annual meeting thing, so there are some associations that didn't have their annual meetings in 2020 because of COVID, and so therefore the board is the same. And now because of the fact that the board carried over, Some board members are serving past their terms. Some, some boards where the terms didn't expire are all up for renewal this year. But in those situations where board members, didn't go off the board, or there's, the board terms are now all screwed up, how would you handle that moving forward in 2021?
Well, I know my approach to that would be, in most documents, a board member's term is actually going to run till the successor is appointed. So I'm generally not too troubled by the fact, given the situation, given the pandemic and all that, if you had a board member that kind of overstayed when the annual meeting would have been, because until that successor is elected, technically I think they have power. It's not something I would recommend normally, but this isn't really a normal time. As far as what we're going to do with the elections now, given if that's the situation we're facing, I think you're just going to have the election and hold all those people up if their terms are over. I think it's important to track what term they had when it was supposed to be up for election, and when you're having your election now, if you're faced with a situation where you might be electing people to different term lengths, make sure you're following your documents, and generally it's going to be whoever's getting the most votes is going to get the longest term. But I would make sure you're trying to stick to your documents parameters and making sure you're having, once things return to normal, you're having board members' terms expire as they should be in accordance with their documents. You want to get back to normal as quickly as possible on this, is my approach anyway.
Part of that is like, do we need to have 2 annual meetings in 2021? And certainly, that's been a common question. And I think a lot of this, as you just said, Dick, is the answer is it depends. If we didn't have a meeting in 2020 and your governing documents require your annual meeting to be, for example, in the fourth quarter, then I wouldn't necessarily suggest waiting until the fourth quarter of 2021 to have an annual meeting. We don't like to have board members quite serving that long, but at the same time, maybe your documents say it's the first quarter or the second quarter. So could you combine the two and elect everybody at once, as Jesse was suggesting? Absolutely. And so that's where, again, it kind of goes back to a specific circumstance. How are we going to handle?
So for those associations that skip the 2020 annual meeting, are you then suggesting that in 2021 you have 2 annual meetings?
If the 2021 annual meeting isn't for a long period of time, then, and we can have an annual meeting now, then I think the best practice would be to have the 2020 annual meeting now at some point at the beginning of 2021. If at the same time we can have it in a way that they both can be held at the same time, that's certainly more beneficial to everybody from a time and administrative perspective. But again, it goes back to, we have a number of instances where we have owners suggesting that boards are trying to hold on to power, and that we were supposed to have a 2020 annual meeting and didn't. And so is it reasonable? I think a court would think it's reasonable that we just wait until 2021, maybe not. And that's why we're gonna have to take the temperature of the community at the time to see, do we think we can get that to fly?
And Jeff, what you just said, I think that's really important, the temperature of the community. And sometimes it is a timing question. I know I got some like, well, we're supposed to have the annual meeting in 2021 in February, and then they're looking, should we have an annual meeting now in November, since we're going to try, well, let's just maybe wait. But also, if you've got a community full of troublemakers that are always after the board, things like this, that's going to weigh on your considerations and how you're going to approach it, what you need to do, certainly. So it is. You're going to take the temperature of community and take a very specific approach to how you're doing that, certainly.
Most communities could look at anybody to serve on the board, so it's not that big of an issue.
And I would say, just regardless of your community and the temperament, doing whatever you can to try to end the stopgap between normal operations in 2020 or prior to the pandemic period. Try to end the stopgap period as soon as practical once everything is starts opening up more and normal operations can resume. And so when you reach that point, operations continue, so that the board members who should have fallen off and should have been elected, those terms are consistent with what should have been if this pandemic period had not occurred.
And something to dovetail on that I would recommend too is, once we have annual meetings, we're getting new board members, I would suggest recommending to the boards to ratify any of the previous actions that happened, just so that once we have and we get back to normal, we can look back and say, look, we realized this was a crazy period. Let's ratify any of those actions just to clean up the mess, or any mess that might be there.
One question I had that kind of came tangentially with all this discussion is about specific procedures for voting. So one solution is to have a proxy vote, or one solution that was offered is about proxy voting instead of holding an in-person annual meeting where the voting takes place in person. If you have a proxy vote, what happens with how do you address the nominations from the floor that is in a lot of the documents? And also I've seen the secret written ballot that's required. So if you have a proxy, and a lot of times it's a directed proxy where you direct somebody to vote a specific way. How do you address the secret written ballot issue if that becomes an issue? So with regard to voting specifically in a annual meeting during COVID, which is done by proxy, how do you address nominations from the floor or things like secret written ballot?
At least for me, Nick, that's where I'm suggesting that in a lot of cases, we need to sometimes do amendments, that we need to address those things and revise the documents so that way maybe we can clarify the nomination process, provide for the use of like electronic voting technology through authorized communications equipment. This is not a new concept for organizations. For-profit corporations have been dealing with this for years. Well, it's more typical for us to just show up at the clubhouse and vote. We've seen organizational governing documents in the typical for-profit sense, particularly in publicly traded corporation sense, that we have very good procedures for this. And there is a number of case law pieces from around the country that address these exact issues, that if the documents say we have to have nominations from the floor, then we actually have to have nominations from the floor. And so we can't prohibit people from then attending the meeting and then nominating themselves. And so for that reason, that's where, again, this is something I'm going to suggest that people review their documents with their attorney and decide, can we proceed based on this in some format? Maybe it's using proxies because those are often permitted, but they might be general proxies and maybe not directed proxies because we don't have all the nominations in yet.
Yeah, and I would say that it's very document specific, just because I have seen associations that have provisions in their bylaws where it says that they can take nominations from the floor, but they also have a provision that says that the board in its discretion can exclude people from attending the meeting if they're in some sort of dispute with the association or for any other reason that it feels is in the best interest of the association. So if they think that a pandemic means that people shouldn't be gathering, they could exclude them, but they have to give them a vote. But then again, you have competing provisions there. So again, that's a community by community issue. But Julia, do you have anything, or Jesse, on that issue?
And again, it is obviously very document specific, but initially your question related to, how do you seek nominations, that sort of thing. And depending on sending out a proxy or sending out a mail vote for some communities, we know boards sent out more of an informal request, as mentioning we're putting together a mail-in vote, document specific or whatever. Please submit if you'd like to nominate yourself, please submit your name. So that way, when it came time for the mail-in ballot and proxy, that sort of thing, you received a ballot and that was sent out to the community. So it was a multi-step process, not necessarily as Jeff said, showing up at the clubhouse and submitting your vote. It really was a multi-step process, sometimes multi-documents, multi-mailings, that sort of thing.
I can say too, how looking at like secret ballots and nominations from the floor, again, look at your documents. We can't repeat that enough. And also generally most associations, they'll say may nominate from the floor rather than shall. So there is some wiggle room there as to what the documents require. And also if you're dealing with a directed proxy where people are appearing via a proxy, essentially there is a floor and there are no nominations from the floor because they're not being made in that sense. But one thing I've also recommended in my community is, given all these things, if you're going to do some sort of a remote meeting or a directed proxy or absentee style meeting, cast a broad net for your nomination. Send it out to everyone in the community. Essentially advise everyone, anyone can nominate themselves. As long as you're eligible to run, you can run for the board and nominate yourself. And in that sense, I think you can eliminate the pool of people who could even possibly claim that they've been damaged by it, because you were allowed to nominate yourself. You were given every opportunity to do so. And if you didn't do so, well, that, the fault's on your end at that point. So I think you can alleviate some risk there by doing that as well. If you can amend your documents and you can get that passed, great. Depending on what they say, you may or may not have to do it though.
Yeah, and again, it is association specific, but I do have one question, and this is if you know, for communities that have been, where the declarations have been recorded, after the pandemic started, so really new communities, do you know if they have language that contemplate what happens if a pandemic situation like this arises and you can't meet in person or not?
I've seen some sample declaration provisions going around that I've commented on. I don't know how many of them are putting in there. I can tell you that moving forward, if any association asks us to do like a cleanup of a declaration or something like that, absolutely am I going to recommend something like this goes in there. It's kind of one of those things you never think you're going to live through or deal with. And then, now, yeah, it would be great if I could turn to a declaration and see, oh, pandemic section, here's what we do. So moving forward, yeah, in general document cleanups, I think I would recommend it. And I know some attorneys have been talking about putting those in new declarations as well.
Julie, did you know if they're in the standard provisions now?
So for the new any new community, or for the most part, any new declaration that our office has been involved in post-pandemic, we haven't, the clients have been including language in regards to emergency situations. I think that a lot of developers are hesitant to bust open the gates to allow everyone to do virtual meetings post-pandemic, just because there could be situations where communities aren't technologically savvy and that sort of thing, or but no, new language is we are seeing new language go into new communities.
Okay, I'm going to move. You got something else to add, Jeff?
Yeah, I would just say the Nonprofit Corporation Act has permitted authorized communication equipment for many years. And so this has certainly been something, particularly in newer documents, that we've seen. It's been more narrowly tailored, certainly, since the pandemic. But in general, I would say for the last 10 years or so, it's been a common theme of newer communities to have authorized communication equipment permissibility for owners meetings more prevalent in documents.
But isn't that statutory section prefaced by unless otherwise provided in your bylaws?
Yeah, and so that's why we've been seeing them in governing documents. I'm just saying that the statute has contemplated this for some time. And so communities and developers and attorneys have been picking up on that. And it's certainly been something that we've been including for many years when we're doing like governing document rewrites and substantial amendments.
Okay, so we're going to move past annual meetings and the annual meeting issues with COVID, but I think the last COVID-related question we have is related to the gym and pool and common facility openings. So for those communities that chose to keep their pool and their workout rooms and other common areas closed in light of COVID this year, what considerations should they undertake? What considerations should they have before deciding whether to open them in 2021?
Nick, I'll jump in on this one. I think that, and again, we've talked about kind of the different phases of the pandemic. Last summer, the guidance, or at least my advice would be very different than it is this summer, just because there was so much unknown. But ultimately, the Ohio Department of Health has permitted swimming pools to open so long as your swimming pool operations are meeting the safety guidelines that they've adopted. You'd also want to consider your specific county or local health department if there are additional or more restrictive rules and regulations, that sort of thing. And with House bills, and the overarching question last summer was, well, even if an association follows all of these guidelines, is there still a possibility that if someone gets sick, could they come back on the association? And I think with House Bill 606 getting passed, if you are a nonprofit corporation, which many condo and homeowners associations are incorporated as such, you are shielded from liability from contracting transmission of the virus, so long as you were operating reasonably, not willful, wanton, reckless conduct. So, obviously it's a tough line to still draw with respect to reopening this summer, but I think that the pathway to success and getting a plan in order and minimizing the possibility for risk and liability to the association at least has narrowed a bit.
No, yeah, I think 606 did a lot to clear all that up as far as the legal liabilities. So that was a good thing for associations, that's for sure.
Beyond the liability, though, it's just, just the general practice of trying to keep people safe. And so that's a consideration. But then another consideration, perhaps even the most significant one, is can we even comply? For restrooms having to be cleaned at pools every 2 hours, that's a fairly onerous requirement that in a lot of association instances are requiring additional funds to be spent on cleaning companies and things of that nature to come in. And so it's figuring out, can we actually comply? And I know many of the managers on this meeting got visits from health departments this summer from people showing up to making sure that they have cleaning schedules and things are happening under threat of shutting down the pool. And so it's not like the health department just put those regulations out there and let them go. It's something we actually have to make sure we can comply with.
Now, on the flip side, what if a board has made a decision to keep it closed because they did take into consideration the health of their members and the expenses involved with keeping them open, and you have an owner or a group of owners threatening to sue because they are paying as part of the budget for the operation of these facilities and they're not in use? How do you deal with those situations?
Bring it.
Yeah. that was a situation last year. That's for sure. We'll see how things change in the summer of this year, but I agree with Jeff. Last year was, I'll take that to court. I'll be on the other side of that, of a condo board that's taken a safety decision and closed due to those considerations.
And the board has the ability to use its reasonable business judgment. And as Jeff said, even if there is a pathway to reopen the pool, ultimately, if the cost and expense is not possible or the pathway is not feasible for the community, I think it may very easily within the board's reasonable business judgment that, look, we can't open this because we can't, or we'll have, but obviously that's something that might end up in court.
To me, it's a political thing than a legal thing. And this, going back to the annual meeting discussion, this board may decide, hey, we're not opening the pool, but that may be very politically unpopular, which is why then the community might really be pushing for, we need to have an annual meeting because we're going to elect different board members who open the pool.
Yeah. Or they try to force a special meeting to discuss that. And they get the requisite number of votes. Okay, so what if the association the board has chosen to keep the common areas closed, but then you have an owner or two owners saying, hey, I need to use the gym I have a medical reason, a medically required reason to use the gym. I have a handicap or a disability. I need to use the gym. Can the association open the gym only for medical reasons? Only allow members with a medical necessity to use the facilities? And if they do that, can they ask for documentation showing a medical need?
The situation definitely led to some odd questions, this being one of them. Honestly, I think if you were going to take this stance, we were going to keep these common elements closed, you'd almost have to look at that as a reasonable accommodation request. If someone was saying, I'm disabled, look, the association has this rule and I need an accommodation from that rule. And so you could look at it that way. If you're dealing with a reasonable accommodation request, you can request some medical information, but it's somewhat limited. If you're getting that particular situation, I would definitely pass that off to your attorneys. You're going to want to look at that pretty carefully. And also, depending on how many of those requests you're getting, I mean, now given the 606 legislation where you're not really going to be subject to liability, maybe you could look at reopening. But I would look at that at a specific case-by-case situation, and also know that you could possibly be looking at a reasonable accommodation style request, seeking accommodation of that rule. So you don't just want to ignore it or reject it out of hand.
Anybody else want to add on to that? An interesting question.
Yeah.
All right, let's move past COVID. I got a lot of other options here. Thank you for sending more questions.
Nick, before you do and move off COVID, it might be worth just saying at this point, how much we all very much appreciate the chapter's leadership over the past year. And you mentioned it in your remarks as to how difficult this year has been. But I think all of the relationships and trust that we build up with each other over the year, seeing each other at events and working with business partners and homeowner leaders and community association managers really has been the foundation for how we were able to get through 2020 very, very much successful. And so, I know everybody's been struggling with these questions, and the fact that we're able to come together and talk about them and rely on our judgment and the people within our industry, because we get to know them and have this organization is really special. And so thank you.
Yeah, thank you, everybody. Now, it does make it a little bit more awkward when I'm transitioning to pet poop here, but the question is, as we all have many, as we all have had many issues with pets and owner responsibility, I'm receiving more questions in regard to our limits as far as registering pets with the association and or testing DNA of pet feces to be able to identify the pet. Generally, what are your thoughts on pet registration, DNA testing for dog poop, things like that?
That's a unique one. Well, many documents include provisions regarding to, no owner shall permit, obviously specific animal permit provisions, but also, no owner will engage in any noxious or harmful activity, and certainly leaving pet mess out in the community is something that is a noxious and potentially harmful item. If it's, I don't think I've ever heard someone mention testing the DNA of an animal. I think that sounds like a very expensive endeavor, because you would not only have to register the DNA of the sample, but then also all of the animals in the community. So that sounds like a very expensive way. Obviously if owners in the community tend to know each other's pets, your neighbors, their pets. If I know that Nick's dog, who I know is adorable, and I miss seeing photos of the dog, if Nick's dog is out walking around, then I can say to the property management company or the board, like, hey, Nick's not cleaning up after his dog. So, I think it's
there's always that situation where like it's clearly in their limited common elements, in their fenced-in area that's just piled up, and they say it's not my dog.
Right.
Like, wait, that's not mine. And it's like it's your fence. So, all right, the DNA thing I think is fascinating, but I'll let one of the panelists describe what's going on here. Jesse, you guys want to describe what this DNA testing thing is?
I mean, I've heard of it. I've never had a community actually do it. But yeah, you can get your dog registered and then take a sample and send it in. Like you said, Julie, it sounds like a really expensive. If you've got a community that has money to spend on DNA, dog testing of feces, perhaps they could maybe better invest that money in just some dog cleanup stations throughout the community.
It's not that expensive. No, it's like $75, and then the associations will make the owners pay that as a registration fee to make sure that their dog is registered, their dog's DNA. And then if they go out in the common elements and find random poop and they scoop it up and send it in and they find out it's that dog and they match it, then that person gets fined, and as part of that has to pay for the test to confirm whose dog it is. But Jeff, go ahead. Sorry.
The cost is not the issue. The issue is the administrative burden. I mean, shoot, we in most communities can't find out who the residents are of the units, let alone who the dogs are, because the owners aren't cooperative. And so do we really want to go through that whole process of trying to get dog DNA registration? Is it really worth it? To Nick's point, is there better uses of everybody's time and resources? I generally think yes.
Okay. Now, transitioning again. Have any of you helped an association transition out of a contract for utility service with a sub-metering company? And if so, how did that go?
Good.
Yeah.
Done it a bunch of times. I did it at the association I lived at and was on the board, and done it many times for our clients.
Anybody else have an experience? I've done it. It's fairly, I mean, it's just, as long as nobody's breaching the contract, it's pretty routine. And you just got to figure out what your contract is with that utility, and follow it to a T with regard to like notice provisions and and make sure that you have, AEP usually ready to step in immediately before you send a notice of termination. So you usually just have to make sure that you have the other utility that you're transferring to ready to go before you give whatever notice is required under your contract. And then the submetering company will work with you and AEP on that transition.
Well, I will say those contracts typically have pretty arduous notice provisions where you really want to watch them. I mean, they'll have, you can't provide it more than so many days, before the contract terminates, and it has to be before that. So you usually have a pretty sweet spot to terminate those contracts. So if you're looking at doing that, I definitely would get that contract over to an attorney or look at it to figure out when those dates are.
From a logistical standpoint, Nick, you're absolutely right. The biggest issue is when the old power goes off, for example, and the new power comes on. You can't have a week of, hey, there's no electricity or there's no water. And so we need to be in a position where you have to shut one off and turn another one on. Oftentimes, though, that may require new like meter banks or transformer boxes, things of that nature. So it might be some time, it might be hours or even a day of no power or no water. And so that's absolutely something that needs to be communicated. Though I will say, interestingly, oftentimes the most controversial thing about doing this is landscaping. Because over time, so many people have put bushes and stuff like that in front of their meter boxes, which aren't really ever allowed in the first place, but they put them there, and now we have to take out all these arborvitae, and people get really upset about that. So landscaping can be one of the even bigger considerations from a practical perspective that people get upset about when we're going through this process.
The only other real roadblock I've seen is if the transition is very soon, and there's like let's say it's, usually they have a 15-year minimum period at the initial period. Let's say the parties, the submetering company and the association agreed to terminate it early. And there's no penalty or anything like that. The problem then is the cost of the infrastructure, because these submetering companies will install the infrastructure, and part of that extra fee that they're paying each month on the bill is to reimburse the company for that infrastructure. So if they don't get fully reimbursed for the cost of the infrastructure, that could be an amount that they try to pass on to the association, or that would have to be negotiated. If it's usually at the end of the first term, usually the infrastructure is already paid back. So that's just one other consideration. But again, if you have specific questions, talk to the attorney about your attorney for that association.
We should just run a disclaimer at the bottom of this whole thing so we can stop saying that,
Yeah. Can't say it enough.
Like a scroll bar at the bottom. Talk to your lawyer.
Yeah. So let's move on to operating reserves. If your documents don't say how much you have to have in reserves, there's no minimum. What amounts do you use?
We're talking about reserves, just all kinds of.
I'm just thinking general reserve. I guess it's just general reserve funds. It said operating. Just talk about just general operating versus reserve accounts and how much should be in each.
I like to just give the general advice to follow the statutes that say we should be putting enough money away to maintain, repair, and replace our major capital items without the necessity of special assessments. So whatever that number is, it's going to be different from time to time, and those reserve numbers are certainly going to fluctuate from time to time. There could be times when it's really high, and there can be times when it's really low. As long as we're planning to avoid a special assessment, that's the safest way to proceed.
Jesse, Julie?
I think that's right. I mean, you got to look at your community. As Jeff said, the whole goal of the reserves is to make sure you're not doing special assessments all of the time. Reserve studies can be helpful for that in planning that. But yeah, that's going to be very community specific. So, I mean, if your documents aren't giving you much guidance, have a study, go out there and look and see what you're going to need to be paying for, and then budget accordingly for that.
And it just depends on your improvements and on your common capital improvements and what the long-term cost and maintenance for those items may be.
Yeah. So I just tack on, you just need to understand what your capital improvements are, your common elements, and understand what maintenance they're going to require and when, and what the cost is going to be. And then you just budget accordingly. And as long as it's sufficient to cover the cost to, repair and maintain in the ordinary course of business without the need for a special assessment, you should be good. And again, there's no set dollar amount, I guess, is what you should get out of this for each community. It's different. And the way you're going to determine that is either through a reserve study or a similar independent study where you just understand your capital items, have the contractors come out and help do projections for you. What do you think makes a successful attorney board or vendor board relationship?
Well, that could be a whole conversation, a whole topic in and of itself. I think two touchstones that you can have are trust and transparency. The board needs to trust that you're going to give them, clear advice, and transparency, especially if you're a manager. Boards like to know what's going on. They don't like to think things are being hidden from them. And unfortunately, it's not something, I don't think, where there's a silver bullet, like do this and automatically you're going to have this great relationship. A relationship isn't something, just by its very nature, that's usually instantaneous. A good relationship's going to be built by, hey, Jesse's told me to do this 10 times and I've listened and everything's gone great. Now I've got a reservoir of trust. Whereas, if I tell you to do something 10 times and it works out horribly 8 times, you might not ask me the 11th time. So, you need to build that. You make sure you're there for your boards, you're answering the questions, you're there for them. I think once they see that you're there for them, working with them, that's where I think a lot of strengths in my relationships come with it. They know they can contact me and they can talk to me, and that I'll tell them flat out what I think their best option is, good or bad. So I think, honesty, trust, transparency, those are how you're going to build any relationship.
The more communication that exists, the less likely that litigation is going to exist. And so, to echo Jesse's comments, the more we're communicating among each other, whether we're business partners with the boards, whether it's boards with their managers, or whether it's the boards and managers with the community at large, the more communication that happens, to me, that's the essential linchpin of success in any organization, but particularly community associations.
Absolutely. No, I think open communication and mutual respect and those are just fundamental for any relationship, professional or otherwise, is just,
The only thing I would
how
add,
can you fix a problem if the communication, how can, in our world, you as a lawyer, you as a vendor, how can you perform your job and receive the service that you're expected, if there's not open communication and true understanding of what the situation is.
yeah, just to tack onto that, the only thing that I think with regard to vendors specifically, I think it's very important not only to have the communication, but to have an understanding of what exactly is going to happen and when. And I think that goes back, don't just take a bullet point proposal and sign it, because it's often missing a lot of important terms. I think you should talk to your counsel and make sure some of those gaps are filled in. It can be a little, frustrating at the front end getting the terms filled in, but it helps a lot in the long run because there's a more clear understanding of, how the relationship is supposed to work and how to hold each other accountable. And so that can alleviate a lot of the issues that come up later. Amending documents. Is there a reason the developer would have written declarations to have 75% membership approval to amend, but the bylaws would require 100% approval to amend?
Julie just had too much to drink that day.
That must have been Tom.
That's right. Okay, fair enough. Tom had too much to drink.
I have no idea.
Yeah, I can't think of a rational reason, why you would set that differently.
I suck to guess what developers are thinking.
It could.
But the bylaws are lower for like a homeowners association. You might see a majority or something like that, but not usually unanimous.
Yeah, I can't, without the specific, maybe there's something in the code of regulations that's particularly for this community, assuming this is about a specific community. Maybe there's something in the code of regulations that was very unusual or some sort of the corporate structure, but yeah, that I can't say.
But there are always a few things that require like 100% approval, right? Which I always think is interesting because, there's always a list of like 4 or 5 things that require 100% approval, but then like terminating the condominium is like 80 or 90%. I don't get that. I would think that would be 100%, but yeah, it's hard to guess what the difference here is. But so if there's a specific question, ask your counsel. Just beating it in every head again. What does an HOA do when they can't get information about a large percentage of owners?
Can you repeat that, Nick?
What can an association do when it doesn't have information about a large percentage of its owners?
You mean like contact information?
I don't know. That's just the question I had, but I'm assuming that it's contact information.
Yeah.
You don't know who your owners are, and you don't know if you don't know who they are, you don't have their information. How do you find that out?
Association ability to do censuses, right? So we're entitled to contact information. If an owner doesn't provide it, we have the ability to take enforcement action, like levy enforcement assessments, just like any other type of violation.
Why are they entitled to that information? Is it statutory? Is it documents?
Statutory, the Condominium Act specifically requires it.
And I guess from a global perspective, the information is public. If you, and I don't know specifically what information this person who submitted the question would be missing, but, if you don't know an owner of record, you can check the auditor's website, you can check the recorder's website for conveyances. If you don't know truly the addresses for the community, those are also public, that's public information as well. With respect to specific contact information, you'd have the mailing address, cell phone, telephone information. I'm not quite sure how far down the rabbit hole this person was going, but with respect to specific contact information.
Well, it certainly is important for condominiums, especially, to have this information. I mean, I just recently had a case where there was, an owner's, the classic case, a toilet's running, it leaks into one unit, from one unit to the other unit, and the unit below wants to know, how do I get a hold of this unit owner? I mean, the association is supposed to have, home address, business address, contact, like home, business, telephone numbers, and the other owners are entitled to that information. I mean, they may need to contact that owner for insurance purposes or whatever. So, especially in the condo situation where you're typically more, closer and have more shared facilities, it's important for associations to get that. And I think Jeff's exactly right. You have the right to get that information, and because you have the right, and owners are actually supposed to provide that information under the statute. I mean, if they're not doing it, that's a breach of the statute and probably the condominium documents as well. You could fine them for not doing it and take action that you need to get it. But yeah, associations should get that information because it can come in, it can be important. And it's nice to have it when it becomes important, not to realize when it becomes needed, like, oh God, we need to go out and start getting this information now. You want to have it when you need it.
Well, owners aren't entitled to all that information, right? Usually just name and percentage interest in the common elements and the address, right? Not specific.
Home telephone number and business telephone numbers provided in the statute as well.
Well, that's what the associations can get, but can owners have access to other owners' phone numbers?
Under the statute, they can.
I usually say no.
Yeah,
I typically don't like to provide it either. It's one of those things that is supposed to be in the association's records, though, and it is subject. It's not accepted out under 5311 as to part of the records that owners are allowed to get. So owners are entitled to get that information.
One of the things that isn't in the statute, though, which often people ask for, are email addresses.
Exactly. That's exactly right. Yeah. And that's why usually we'll have the email, but we might not have the telephone number. I've told it, even though we have the email, since it's not explicitly in the statute, I don't like to, I tell them don't provide it because it's not set forth in there.
All right, so we've got a couple more questions here. Past due association fees during and after associations, or during and after COVID. Collection issues involved in that. Can you speak to that?
I imagine we all can probably speak to it. I mean, it might all have something to say. I generally haven't seen a huge impact on collections pre and post COVID. I've seen some. I've got a fair share of cases where the CARES Act came out, or even the courts themselves came out and would stop collection actions. And I still have a few cases that are stayed, but generally the associations, you're able to file something to get out from under that stay. So I guess largely, like systemically, I haven't seen a lot of institutional stops to stop us. But I have a few associations where they may have waived late fees or they've loosened up their payment plan, what they're willing to do as far as that goes. But generally, I haven't seen like a huge issue with collections and COVID. At least that's been my experience.
I would agree. We're generally able to proceed when we need to. Boards have been more liberal about payment plans and waiving late fees, and courts have generally allowed everybody to proceed. So we've been doing so. But at the same time, I would say with stimulus and everything else, we've seen a higher rate of people actually paying and paying on time. People have money, and people who have been delinquent have often been using that to pay it off to avoid their situation. So from a collection standpoint, usually things have been going pretty well, but boards should absolutely continue to follow their collections procedures and making sure that we are collecting if people are falling behind, at least initiating that action.
And I know we would get, because the broad headlines and that sort of thing, foreclosure moratorium, and we were having this discussion just before the panel started that for your own reference, the foreclosure moratorium, it only relates to lenders. It doesn't necessarily relate to condo association or homeowners association foreclosing on their liens. Obviously, if it were to go down the foreclosure path, there could be a situation where the lender, that could cause association's foreclosure action. But I mean, there's from a legal perspective, obviously practical and the individual board's policy decision, that's a different question. But from a legal side, associations can move forward.
Yeah, and one thing I can add too, though, if you have a community that maybe typically has waited for a bank to initiate a foreclosure, rather than being more aggressive on your own, maybe know because of the CARES Act and because it's been extended, I have seen banks delay foreclosures or file a foreclosure and then just sit on it. So if you have a community that's thinking, well, the bank filed foreclosure, so we're just going to wait in the background, you might be waiting for a while. So you might want to reevaluate that position and have the association join and bring their own claim or push that action themselves, because the banks aren't moving quickly right now.
Do you know if the CARES Act or any other federal legislation makes funds available for delinquent condo assessments or HOA assessments?
You mean like directly to associations, or?
No, I guess to the owners who would need to pay them.
I think that would be an interesting question. So CARES funds have provided, part of the CARES Act provided a lot of revenue or funds to local governments. And local governments have the authority to make all sorts of relief programs. I think that a local government might be able to create a relief program, but I haven't heard of anything specific with respect to funds being set aside to be allocated to a homeowners association or condominium associations.
The only thing that has gotten us close is our clients that have actual employees, not through a management company, that they actually have W-2 employees. They might be eligible for some of the grants or the PPP funding, but that's about it.
Okay. So I have one independent question and a couple more cleanup questions on two issues, and then I think we'll kind of shut it down here. So the new question is, can an association work with its attorney to audit the governing documents that are provided to unit owners to make sure that all historical amendments are included? It's often difficult to cross-reference the docs managers have on file with the county recorder website. So basically, can managers contact the association council to make sure that they have, the association has all of its governing documents on hand?
Sure.
Yep. Yes. That's one thing. Contact your counsel. They'll help you with an answer. One question regarding owner contact information not being obtainable or being, I guess, obtainable to other owners. What about the Privacy Act and people only providing their name?
Well, again, the Ohio Revised Code 5311 states what information, as far as contact information, the association is entitled to. So, I mean, the association is entitled to that legally, and then it also sets forth what records other owners can get. Now, this is separate from, I've seen some associations publish phone books or directories. If an owner doesn't want to be part of some optional thing like that, don't publish their information. But the association should be maintaining certain contact information in their books and records. And other owners do have the right to inspect the books and records subject to certain exceptions. So I'm not worried about the Privacy Act as far as, inspecting the contact information that you validly collected pursuant to the revised code. But again, if you're looking at like publishing or providing this information to third parties who aren't owners, that I would not recommend.
People make the mistake of believing they have more privacy, particularly in a condominium association, than they actually do. The laws that apply to HIPAA and banking institutions and stuff don't apply to us. And so Jesse's right. The statute says we can have all this information and other people are going to be able to get copies of it theoretically.
And by purchasing a unit in a condominium, they're agreeing to do that because a lot of the documents require them to provide it anyway. So they're contractually bound to provide the information, and they voluntarily did so. Last question that I have is about an operational reserve account. It says some documents say that you have to have an operating reserve of 1 to 2 months assessments. Is that the same thing as a general reserve account, or are those separate? And if so, how so?
So if your documents provide that you should have two separate accounts, then you should maintain two separate accounts, and the specific purposes for those accounts may be included in that as well. But in general, operating reserve would be funds to again, the day-to-day operations, to keep current on all of your contracts and keep your insurance up to date, that sort of thing. But the reserve account would be for those more saving up for capital improvements and just larger funds and fees that may come up as the community ages.
The one thing I would just add on to that is that associations, when dealing with these financial matters, should talk to their accountant or their tax professional, just because as nonprofits, associations generally don't have the ability to hold over funds from one year to the next unless they're for maintenance, repair, and replacement of major capital items without incurring some tax liability. And so there have been instances I know of where accountants have advised that they can, when there is those two requirements, that they could use reserve funds to satisfy the other requirement to try to get around the taxation issue, just because we normally just can't hold over money for operating expenses without incurring tax liability. So talk to your accountant too.
You raise a tangential question that I want to make sure everybody's clear on. Associations, community associations, nonprofit, correct?
Yes.
Does that mean that they're tax exempt?
No.
Okay. So they need to file a tax return, correct? So
Yeah.
make sure that's clear to your boards.
They're corporations, so they file an 1120, or there's a specific form called an 1120H for homeowners associations. But associations are not, the charitable, religious, or fraternal 501c3 type of organizations. Though I'm sure all of our communities are charitable, religious, and fraternal people. We don't qualify for that typical tax exemption from, for example, the state of Ohio's sales tax exemption.
All right, Elad, I did get one more question, and this is going to be the final question. Can an association or a management company require online payments or charge for paper checks?
I'm gonna say my initial thought first off is I don't think I would recommend that. Moving beyond that, generally the revised code gives the association the ability to adopt rules for collection procedures and governing that. So theoretically they could. I've not seen an association do it. I wouldn't necessarily think I would like to see that if you had someone challenge it. I don't really see anything in my head that would necessarily stop them from doing so. That's my thought on it anyway. I'll throw it up to my peers here.
I would agree with Jesse. My thought for a reason against that was if someone wants to give the association money, take it in any form that it may come. Obviously administrative convenience and that sort of thing, but I would agree with him. I think that it may be possible, but to require one specific, I think that I'd recommend having a good reason for just having one specific form of payment.
We have done what I will call method of payment governing document amendments that provides for specifically that. You have to do whatever the payment the board requires, and anything outside of that, we can charge an extra fee for. And in large part, it's because, you know, the process of printing coupons and stuff like that gets more and more burdensome and expensive every year for people, the manual process of payments. And so boards want the ability, and management companies want the ability to charge for that. But yeah, I mean, given the fact that it is sensitive and we generally do want to accept money everywhere it comes, that's where I think that the safest way to do it is get 75% of the owners to say, yeah, that makes sense, and put it into the governing documents before we do something.
Yeah, I agree. Again, I think theoretically you could pass a rule, but I wouldn't like it. It's not something I would recommend. I think if you're going to do that, I probably would recommend, like Jeff, to amend that just to make sure that everyone's on board and it's somewhat unassailable at that point.
All right. As a man of my word, that's the last question. I want to thank all of you for serving on the panel. Julia, Jeff, Jesse, thank you very much. I think barely anybody signed off while you were in the middle of your panel. So you at least captured their attention and you did a very good job. So thank you all again for doing that. And thank you to everybody for attending and for entertaining us in this virtual format. It's different. We're still adapting, and we thank you very much for attending. With that, we're near the end here. I want to thank you again. Thank you for allowing me to serve this chapter for 6 years. So now I can step off for a little bit. I want to thank again all of our sponsors and our business partners. You've been very accommodating, very generous, and we look forward to meeting with everybody in person here soon. For those of you that are still on the board or new to the board, Brandy will be setting up a meeting with you soon. Not today. Usually we have our first board meeting right after the annual meeting. It'll be a little bit delayed, but Brandy will be in touch soon to have that meeting. And with that, somebody want to do a motion to adjourn from the floor? Since we have 3 people we can see. Jeff, you're going to make a motion to adjourn? Is there a second here?
A second.
All right. Anybody in favor? Or all those in favor? Anybody opposed? All right. Motion passes. And with that, we will adjourn at 12:45 p.m. Thank you again, everybody.
Thanks, Nick.
So.